All right, folks, my name is Jeanne Minno. I'm an attorney with Topeka, Daly, Pope, and Perry. We are a law firm with 5 offices throughout the state of Connecticut, Berlin, South Windsor, Madison, Simsbury, and New Milford, and I'm in the New Milford office. And that is the extent of, this is not a sales pitch, so that's all you're going to know about me and the law firm. We're here to talk about estate planning. What is estate planning? What's it all about? Just to go over some of the ground rules, at home people, I am sorry, you're all muted. That's just to avoid any, what's for dinner? I don't know. Well, you tell me, that kind of stuff. That's what I'm saying in my house. Dogs barking, stuff like that. I'm going to talk about questions in a second. But I just want to let you folks know that's why you're muted, just to avoid any ambient sounds, because it can get a little confusing. Estate planning, what is it? Why do I need it? We're going to talk about a lot. I'm going to try to get it all done in an hour. So please tell me if you can't hear me. And if I'm talking too fast, if I mumble, I've been told that by my husband that I mumble. So please tell me if you can't understand me. So estate planning, it's more than where does your money go when you die? Where do your assets go when you die? I'm just going to do sort of a brief overview, and then we're going to get into a lot more detail. It does have to do with what if you become ill? What if you become incapacitated? Who do you trust? It's important to sit down with somebody. It doesn't have to be me. Go over your deed. I cannot tell you how many times I've had folks come in and we look at their deed and it's not worded the way it should be. They don't own it in survivorship. They own it as tenants in common, and it's not going to go through, it will have to go through probate. There's dangers of putting your kids on houses and accounts sometimes. It's important to go over your accounts. How are they held? Do you have beneficiaries? Blended families, dysfunctional families, we all have them. What are some of the pitfalls of that? What are some of the ways you can protect your assets? Medicaid planning. And if you do have existing documents, go over them. At least I can only speak for myself and our firm, but I'm not here to sell anybody things they don't need. If your documents work, that's fantastic. But sometimes folks have documents that are 20, 25 years old, and you have guardians for kids who are 27 years old, and your brother-in-law who is your executor, maybe you don't really want him to be your executor, maybe he's not even your brother-in-law. Maybe those kids can now move up into better role. Where is the original? You really have to have your original will when you pass away. Did the attorney who drafted it, do they still have it? Is that attorney still around? Maybe they retired, maybe they passed away. So these are all some of the things that we really want to take into consideration when it comes to estate planning. These are the topics we're going to be discussing tonight: durable power of attorney, healthcare directive, which includes a living will, appointment of a healthcare representative, conservator, designation of remains. I know it's like the worst topic to talk about, but it could be important. Last will and testament, and trusts. That's a lot to pack into an hour, but you can do it. Questions. All right. So I love questions, but I do ask, if you're watching online, please free to ask questions in the chat, and I'll get to them at the end. If you're here in the room, I kind of ask that you ask questions after we hit each document, and just raise your hand. So starting with the power of attorney, everybody should have a durable, long form power of attorney. I actually think this is one of the most important documents that a person can have. It's a document that appoints the agent or agents of your choice to help you with legal and financial affairs while you're still alive, but unable to do so yourself. And it's important to pick somebody you trust. That's the key. What can a power of attorney do? A power of attorney can help you with banking. It can help you with investments. It can the firm puts excess safe deposit box. I'll be honest with you, banks are very touchy about safe deposit box, and a lot of people don't even have them anymore. Technically, yes, it can access a safe deposit box unless you put the power of attorney in a safe deposit box. Don't do that. It can help you safeguard assets. It can assist you with tax matters. It can't change or invalidate your will. It dies with you. So if you pass away, your power of attorney is no longer in effect. It can't change the power of attorney to someone else. And the agents you choose have a fiduciary duty of good faith. They have to act in line with your estate planning wishes, and they have to substitute your judgment for theirs. So here's an example of the beginning of a power of attorney. We're going to go into a little more depth, because you know what one of the pictures is. So Ralph Cramden, presently of 123 Main Street, appoints his spouse, Alice. A lot of times married people, that's who they would pick, right? You pick your spouse to be your primary agent. And then you name backup agents. So when you name backup agents, you can name one person, you can name a child, or you can name two people. When you name two people as your agent or your successor agent, you can name them separately. Now, so first in line is Alice, she's an agent. You normally would pick your spouse, unless you have to sort of think this through. If you're older and your spouse is starting to develop some cognitive decline, then maybe you don't pick your spouse, or you pick somebody else to work with them. So that when you're picking your successor agents, you would pick them separately. What does that mean? So that would mean Alice is out, she can't do it anymore. Ed and Trixie are acting separately. Ed says to Trixie, I need you to go to the bank for Ralph. I'm swamped today, I can't do it. Trixie can say, sure, Ed, no worries, I got that, but I need you to take care of the taxes next week. Sure, no problem. That works. Now, when you're thinking about children, if you're appointing two kids to act separately, you have to think this through. So if you have two kids that communicate well, they're both trustworthy, they're both the kind of kids that are going to work well, you can certainly name them separately. If you have two kids that are going to say, well, okay, John, I need you to go to the bank for mom and take care of this. And then John says, well, I do everything around here, so and I hate that bank. Why are we going to that bank? And what are you doing? That's not going to work. So you have to sort of think it through, the people you pick. Severally means they're going to communicate, they're going to work together, and they're not going to work at cross purposes. And again, the important thing is that you're picking people that you trust. So if Ralph starts to think, you know what, maybe Ed's not the guy. Maybe, he's gonna put this off. He's not going to rise to the occasion. Then Ed's not the person to pick. You need to pick people who are good with money, good with finances, people that you trust implicitly to help you should you need it. Next, we've got to start talking about some of the powers. So on a power of attorney, there's standard powers and there's hot powers. So the first 2.5 pages of a durable long form power of attorney are very standard banking, tax matters, pretty, again, basic powers. In 2016, Connecticut adopted the Uniform Trust Code. And it also adopted the long form hot powers. So it brought about a lot of changes. So after 2016, if you execute a durable power of attorney that's in line with the Uniform Trust Code, number one, a bank or financial institution can't say it's old. They can't say, if you did a durable long form power of attorney in 2017 and it's in line with the Uniform Trust Code, and your agent goes into a bank tomorrow, they can't say it's old. They can't say, well, this is 8 years old. Why should we take this? They used to do that. Certain banks, especially Wells Fargo, used to say, well, this is too old. Sorry, buddy, you got to go get a new one. And that may be impossible because the person who signed it may have lost capacity to execute it. So again, this is another one of those occasions where if you are the agent for somebody, or if you have a power of attorney, look at it. And is it old? Is it from 2014? You may not be able to use it anymore. Another thing is the power of attorney you have a short one. These hot powers scare people. I'm like, they're like, whoa, making gifts. I'm not doing that. Greater change of beneficiary designation. That's no. But a lot of them are geared towards Medicaid planning. So for instance, if you see create, amend, revoke, and fund trusts, a lot that's really geared towards something called a pool trust, which I'm not going to go into because I'll be here all day. But if you want to apply for Medicaid at home, a pool trust can be an invaluable resource. Gifting, but if I become severely ill and I need to apply and I need to go into a nursing home and I want to apply for Medicaid, my house is a saved resource from my husband. He can keep the house, but we got to get it in his name. So we own it jointly. I'm incapacitated. I can't sign a deed. If he has a durable long form power of attorney that allows gifting, he can. He can sign the deed gifting my share of the house to him. If he doesn't have that gifting power, he can't. So the powers are scary, but they can be very valuable if you need to apply for Medicaid and assets need to be shifted around in order to save them for the well spouse or in other situations. You look like you really want to ask me a question back there. Did you have something you wanted to ask me? So that would probably go into more of a Medicaid. If you want to come up at the end, I can talk to you. But that's like, oh, that's a Medicaid. I could be here. I could literally talk to you for 45 minutes from a Medicaid plan. Create or change a beneficiary designation. Again, I don't want to get too lost in the weeds, but this actually happened to a couple that was in my family. The husband had a chronic disease that wasn't going to kill him, but it made him incapacitated. The wife was fine. All of a sudden, the wife, boom, wasn't fine. She got a horrific diagnosis that said she wasn't going to be here in 3 months. Luckily, we had a really good power of attorney. Their beneficiaries were a mess. We had to go in and make sure that all of her assets had her husband as a beneficiary and all of his assets didn't have her, went to his kids. And thank God we did, because otherwise it would have been a mess, because she did pass away. She passed away within months, and then we were able to fix it all. We had to fix it quick. So you just don't know what life is going to throw at you, not only Medicaid, but sudden illnesses. So the key is having a power of attorney should not be scary as long as you make the right choices. Your agent does have a fiduciary duty to follow your wishes and act in good faith. Does that mean that occasionally you don't have an agent that goes rogue? Unfortunately, no, but you have to keep an eye on who you pick and their behavior. And if you feel that pick your son as an agent and then you're starting to worry about him and you feel like someone's getting in his ear, you revoke it. Only pick people you absolutely trust. Don't pick, your son and your daughter-in-law because you think, well, that's who I should pick. If you don't trust your son and your daughter-in-law, don't pick them. And the most important thing that I tell everybody is when you sign your power of attorney, don't give it to anybody. Don't scan it. Don't copy it. Don't put it on file in the bank. If you're in a position where you're perfectly healthy, perfectly capable of handling your own finances, if you're married and you're picking each other as your first agent, put it away. Put it in a safe, put it in a strong box. Let your agents know, oh, I've designated you as my agent. Here's where it is, but that's where it stays. And if they, oh, but yeah, you really should email me just in case. No, my attorney said no. Not because you don't trust your agents, but because computers can get hacked, things can happen, and if it's not out there, they're not going to use it. If an emergency happens, they can get it and they can find it and then they can use it. Does anybody have any questions about powers of attorney? All right, we're moving on to living wills and healthcare representatives. So a combined healthcare directive should cover a living will. We're going to talk about each one of these. A healthcare representative or representatives, appointment of conservator, organ donation, HIPAA, and it can be modified. It's a fluid document. I have had folks who were Catholic and wanted the last rites incorporated. I have had folks who were Jehovah's Witnesses, and there were certain aspects of that belief and faith that they wanted incorporated. I've had folks, I'm a big pet person. I've had folks who wanted it written in that if they became incapacitated suddenly and they live alone, they have pets at home. And they want to designate someone who can be called to go and take care of their dog, their cat, whatever it may be. So it can be modified to anything that you would like. A living will states that if you are in a persistent vegetative state and your brain has ceased functioning, and R says 2 physicians, one who is a specialist to make that diagnosis, have said that your brain has ceased functioning and not coming back, you're saying we do not wish to be kept alive by artificial means. Artificial means is defined as breathing tube, artificial respiration, CPR, and artificial means of nutrition and hydration. You don't have to say that. If you want one or all of those measures, that is certainly a decision you can make. But it's important because the way I explain it, and I tend to get emotional when I talk about this, but the way I would look at it for myself, it's a very personal decision. And if I'm in that state, if I'm in that situation, and there's people that I love sitting around the hospital room, I don't want them to face that decision. I don't want them to have that agonizing decision. I'm telling them, let me go. I don't want to live like that, and I don't want that. That doesn't mean you all want that. I'm saying I don't want that, and I'm giving them the gift of saying, I got this. You don't have to make this decision. I'm telling you right now, that's what I want. But it is different than a DNR. Sometimes those terms do get sort of used interchangeably, but they're different. A DNR is something that you would sign with a physician, and only when you're older or have a condition, which means that you're at end of life. End of life is sort of on the horizon, because that means that you don't want CPR under any circumstances. So if I'm out at steakhouse and I choke on a piece of steak and my heart stops and the EMTs come in and I have a DNR bracelet, they can't touch me. They can't give me CPR. So they are different, and it's important to know that distinction. You only sign a DNR with a physician. You don't sign those with us. So again, DNR is put the place with the assistance of a doctor. It's only CPR. Living will, it says that if your physician must certify that you have a terminal illness and your brain has ceased functioning, and it acts as your voice when you're unable. Healthcare rep, this is a different skill set than a power of attorney. Power of attorney is someone who's on the ball with finances, organized. A healthcare rep is someone who's going to be stoic in the face of what could be a very emotional decision. Someone who's going to follow your wishes. Someone who's going to just remain strong, again, which could be something that's a very emotional circumstance. So you can pick one person if you're married. Most people pick their spouse. And if not, you can pick 2 people. Here you can pick joint. So if I have my husband first, I have my stepkid second. So if I pick my stepkids severally, that means they call one first. If he doesn't answer, they go straight to the second one. Jointly means one sitting in the hospital room with me and he's ready to make a decision. The other one's on a plane somewhere, his phone's in airplane mode. Then they can't make a decision without him. It also means that stepson 1 says, well, let her go. You know, we inherit everything if she goes. The other one says, no. Let's keep her alive for a lot longer. She was, she was really good to us. they're at an impasse. They can't make a decision. So it's important when you're picking healthcare reps to think it through. Who's going to follow your wishes? If your living will says you don't want to be kept alive by artificial means, don't pick somebody who's going to say, I don't care what that says. You're keeping her alive for forever. A healthcare rep can't make medical decisions if you have capacity. If you're sitting up and you're eating your dinner, your healthcare rep can't come in and say, all right, well, I'm here, I'm in charge. That's not how it works. You have to be unconscious. You have to be incapable of making decisions for yourself. Designation of conservator. If you're not saying that you need a conservator, again, it's rare, but if you develop a cognitive condition such as Alzheimer's or dementia, where you rip up your health care and you're not taking care of yourself, you're telling the probate court in advance that the people you've named as your healthcare rep are the same people you'd want to be your conservator. If your cognitive condition is such where you're telling the probate court, don't listen to my family. If I'm saying they're trying to kill me, don't pick them. You don't necessarily want them to listen, because then the probate court's going to appoint attorney so-and-so who's going to charge $400 to be your conservator. You want your family, you want your husband, you want your kids. They know you. They're the people best equipped to take care of you. You want to be an organ donor? If you do, are there restrictions you'd like to put in place? And a HIPAA release. This is very important, especially if your healthcare representative is not your spouse and not your biological child. For instance, my stepkids are my backups. I don't want some doctor saying, well, sorry, kids, can't really tell you anything because you're not biologically related. No, I want those doctors to tell them everything. If they're making important decisions regarding my care, I want a HIPAA release in there so they know everything. Disposition of remains and appointment of agent. This is, again, not the cheeriest of topics, but it's important. And this is another document that has come in, you'd say handy because it's, it's a bit of a dark topic, but it allows you to execute a document designating an individual to have custody and control and disposition of her body when you have died. And you think, well, I don't think that's so important. It is. For instance, I just had a woman, she was with her partner for 30 years. They were not married. And her only biological relative was her sister, who she really didn't like. And she really didn't want to have anything to do with anything. Luckily, we did a designation of remains. She passed away, and her partner, who she loved dearly and he loved her, went to the funeral home. The funeral home said, well, I'm sorry. He forgot about this document, and they said, well, I'm so sorry, you can't do anything. You can't make any arrangements for her. We're going to have to call her next of kin. Luckily, then he remembered that he had this document, because otherwise they were going to call the sister that she would have been very upset about in the hereafter. So, especially if you're not married and you don't have biological children, this document is very important. Even if you don't know if you want to be buried and you don't want to be cremated, it's important to designate the person who you want to be able to make those decisions for you. Does anybody have any questions about healthcare? Yes, sir.
Someone can come make that.
So if your healthcare if you say that you don't wish to be kept alive by artificial means, and I'm not a healthcare provider, and I get this question a lot. If you say you don't want to be kept alive by artificial means, and your wife says, is your healthcare rep, and she says, I don't care. You keep him alive by whatever means necessary. Hospitals are not going to want to upset a grieving spouse. They also don't want to get sued. My guess is it would probably go up to ethics boards, and it would just drag out a very sad situation. I don't know exactly what would happen, but it certainly would drag it out, because they're not going to say, well, sorry, grieving spouse, we're just going to do what this paper says. It would probably, and again, I'm not a medical professional, but I would imagine it would go to legal and ethics boards and all the things and. Yes, ma'am. The power of attorney is only for legal and financial matters. So of those at home, the question was, does the power of attorney work for health matters? So the power of attorney is for financial and legal, and then the healthcare directive is for health. Well, I mean, you could name the same person, so conceivably they would have overlap, but no, they have separate, they're for separate purpose. So moving on to will, wills are important. I'm a walking, talking example of why wills are important. Because if you don't have a will, you are giving the state of Connecticut to right to decide where your assets go. You're going to be under the laws of intestate succession. And I always use me as an excuse. When I got married, I owned a house in my name alone. My parents are thankfully still alive, and my husband has 2 children from his previous marriage. My husband has 2 cars and a motorcycle in his name, and we didn't have any wills. I didn't do this kind of law. I was like, we'll get to it. But the laws of intestate succession say that if I died without a will, anything in my name alone, my husband would get the first $100,000. My parents would be entitled to 25% of my residuary estate, anything in my name alone, which would be half that house. So, and anything else that I might have floating around in my name, I wasn't very good at making sure my stuff was together. So my parents could have said, well, you know, she wasn't cheap to raise. So yeah, we want that 25% of that half of that house. If they were on Medicaid, they wouldn't have been able to disclaim it. They would have had to have taken it and it would have gone to their care. My husband has 2 children from his previous marriage. His children would be entitled to 50% of his residuary estate. Oh, I love those kids dearly. And, you know, they're named as, you know, backup people in our will, but they can wait. But I wouldn't have had that option. They would have been entitled to 50% of one half of the house. They would have been entitled to 50% of the cars, 50% of the motorcycle. So it is something to sort of think about, that not necessarily everything you think is going to go to where it goes goes where it goes. Make sure your beneficiary designations are titled properly, and your assets. So like I said about houses, if your deed says, if you're married and your deed says joint tenants with rights of survivorship, that's good. That means you own it with rights of survivorship. If you bought your house after 1984 and it says joint tenants, that's good. That means you own it as right to survivorship. But I can tell you, I have had people come in that their deed says to John Doe and Mary Doe, period. That's not good. That means that they own it as tenants in common. And it seems to happen, it's not done with any, you know, bad intent. It's, for some reason, construction companies, I don't know why, they just don't think about it. But that means that if I own my house as Jeanne DeMinno and Frank DeMinno, period, and I die, my husband has to go to probate to get that. I own 50%, he owns 50%, and it doesn't mean he gets it automatically. It means that he's got to go to probate court to get that 50%. And I've seen it happen. And I've seen it happen with blended marriages, where had one of them passed away, their kids would have gotten, their kids from a previous marriage would have been entitled to 50%. So it's just important, look at your deeds. And beneficiary designations, those don't pass by way of your will. So again, I've seen it happen. People have 3 kids. They've got a $500,000 IRA and they leave it to 1 kid, thinking, well, yeah, I'm just gonna leave it to 1 and he'll take care of it. Don't do that. No, don't do that, because then that child, first of all, it belongs to that 1 child. And that child can say, well, sorry guys, mom liked me best. It's all 9/9. They don't have to split it. And if they do decide to split it, it's an accounting nightmare, because that child is going to have a huge tax burden. It's a taxable event to have an IRA. So it's, again, it's just important to sit with someone and go over your beneficiary designations and make sure they say what you want them to say, go over your deeds, make sure they say what you want them to say. Does anybody have any questions about this? Mhm. 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 It depends on what it says. So the difference between, actually, I want to go back to both too, because I forgot some parts. The only difference between a quitclaim deed and a warranty deed is when you purchase a house for money for the value of the house, you get something called a warranty deed. And that means that the person who's, and I don't mean to like do a real estate tutorial, but a warranty deed says, I'm going to sell you my house. You're going to give me the market value money, and so I'm telling you that it's free of claims, it's free of liens, it's all good. You're getting a pristine, crystal clean, lien-free house. Quitclaim says, oh, I'm just giving you what I got. I'm not making any warranties to you. That you're just accepting what I got. I'm giving you what I got, and you're getting, and that's what you're taking. So that's a very simplified version of the difference. But it still has to say what you want it to say. So it's a matter of what's written in the deed. Okay, but going back to wills, because I just want to circle back to, it talks about your tangible personal property stuff. We normally don't itemize your jewelry and your furniture and your clothing unless it's something big. If you have a $50,000 painting on the wall, okay, but if I say I'm going to give this ring to my stepson David, and then life changes and I give it to Alex, and personal feelings are going to get hurt, and David could put in a claim for the ring. So it's better to just say all of my tangible personal property to my spouse, ultimately, whomever, and then you leave a list. You make a memo. If I say that I'm going to give this to David, then I can always change it down the line. It's just a piece of paper that I'm going to keep in with my stuff. Your residuary estate is everything in your name alone when you pass, not beneficiary designations and not jointly owned. Anything in your name alone, which could just be your house. You need to decide about it. Your executor. Who do you want to be your executor? Are any minors going to inherit money? So if my stepsons were still young, I would put in a minors provision, or I would put in a minors provision anyway, because maybe God forbid, maybe one of them is going to predecease me and have children of their own. You sort of have to think about the ages. If these people are already in existence, but let's say my stepkids are 16 and 18, and I'm thinking, all right, I don't know. You start at 25 and you sort of think about it a little bit. Like if they're kind of immature, I could say half at 25, half at 30. The money can be used for their benefit. It can be used for education. It could be used for whatever they might need, but they don't get a check in their hands until the age you decide. Is there anybody in your line of beneficiaries that has special needs? Is anybody on a needs-based program such as Medicaid or SSI? Should their money be tied up in a special needs trust? Should it be tied up because maybe you're worried about your son, maybe that marriage is a little shaky, and you're worried that if you're going to leave him a substantial amount of money, it's going to go to a nasty divorce. You can tie money up in a trust. We're going to talk about that a little bit more when we go to trusts. But there's things to think about. If you are going to have a trust, who's going to be the trustee for that trust? Who's going to be trustee for this trust for the kids? There's two schools of thought. So if I'm picking my stepkids to be the executor, and then I'm going to make minors provisions trust for their kids, I'm inclined to pick David to be the trustee for Alex's kids and Alex to be the trustee for David's kids. Some of my coworkers say the surviving parent of the child, the moms. It's really a matter of personal choice. If your daughter-in-law is like a second daughter to you and you trust her to be the trustee, okay. I mean, It's really a matter of personal choice. But moving on to trusts. There's two kinds of trusts to talk about, and this is a biggie, so I tried to say a lot of times, and everyone wants to hear about trust. There's revocable living trusts and irrevocable trusts. So revocable living trust. Why does everybody say I need one? Spoiler alert, not everybody does. I'm not going to be one of those people who's up here and says everybody needs a trust, because not everybody does, but some people do. So there are some reasons for funding and using a trust. So I'm going to go through these one by one. Real estate out of state. If you have a home in Connecticut and a vacation home in wherever this beautiful place might be, maybe Massachusetts, Cape Cod, Rhode Island, then yes, a revocable living trust is a good idea, because then your heirs don't have to go through probate in two different states. It can be a hassle to have to be probate in Connecticut and then probate in another state. A blended family. So if Mike does his will that says everything to Carol, alternately everything to all 6 kids, Carol does a will that says everything to Mike, alternately all 6 kids, Carol dies first, Mike can change as well and be like, shh, those girls ain't mine. I'm going to leave everything to my boys, and then sorry, Marcy, Cindy, and Jan, you're not getting anything. If you do a revocable living trust, when Carol dies, we do a Mike trust, we do a Carol trust. Carol's trust becomes irrevocable. So Mike can't ace out those kids. Family with conflict. This is where, if you have a child or beneficiary that has a drinking problem or a mental health concern or a bad marriage, and you want to tie up their money in a sub-trust, it is easier to do it in a revocable living trust instead of a will. So if I do a will and I say, sorry, Alex, I just don't trust you with money. Your money is going to be tied up in a lifetime trust, and your brother David's going to be the trustee. When I die, then that trust doesn't exist until I die, and all of Alex's money goes into a trust, but there's probate court. The probate court is going to be forever involved in this trust for Alex. So David has to do an accounting to the probate court the first year, and every 2 years thereafter, he has to do an accounting to the probate court. There's always going to, because the probate court was involved in its inception, and the probate court is going to be involved thereafter. If it's done in the body of a living trust, there is no probate court, there is no probate court oversight. So David, he has a fiduciary duty to his brother. He has to make sure that it's all, the T's are crossed, the I's are dotted, but he doesn't have to report to the court every year. Let's say I want to disinherit somebody. I'm going to pick on David this time. So let's say I'm just disinheriting David. He's out. If I do that in a will, there's an open forum in probate court for him to stamp his feet and say, that's not fair. Alex got in her ear, and it could be just a big mess. If it's done in the body of a trust, there again, there's no probate court. It doesn't have that open forum. As long as everything's in the name of the trust and nothing's going through probate, then he would have to hire an attorney and sue the trust, and it's a lot harder. So if you have a conflicted family, then trust can be very beneficial. Estate tax. So right now, the estate tax limit in Connecticut follows federal, and it's almost $15 million. So we're not really worried about estate tax right now. If it changes and you find yourself up there with the estate tax, then yeah. What could happen is, let's say Lovey and Thurston have $20 million, which they might, and this is today's, or you never know. So if they could do something called a disclaimer trust, I'm going to spam on this, but so first, Thurston dies first, and he leaves a trust saying that he leaves everything to Lovey, but she has the right to disclaim anything over that 15 million threshold. So Lovey would put 7 million in something called a disclaimer trust, leaving her with 13 million, which is under the threshold. That 7 million is hers. She can spend it. She can do what she wants with it, but it's technically out of her estate. So if she dies, she only dies with 13 million and she avoids paying estate tax. So there are many reasons for funding and using a trust, but here's something very important that a lot of folks don't know. I didn't know until I started doing that. If you own real property in the state of Connecticut, you never really avoid probate. And if any of you have had family members or spouses who have died with real property in the state of Connecticut, you may already know this. And it doesn't matter if you own it jointly, and it doesn't matter if it's in a trust. You have to file something called 706 NT. The state of Connecticut has an invisible lien on your house. So my husband and I own our house jointly. My husband, sorry, honey, passed away. And I don't know any of this. And I say, well, I don't have to do anything. Everything was joint. Everything had beneficiary designations. So I'm not doing anything. I'm good. I die 10 years later. My stepkids go to a lawyer and say, and the lawyer says, and we do this all the time, well, what did you do when your dad passed away? What did your stepmom do when your dad passed away? I don't know if you do anything. Wrong answer. So they would actually have to go back and recreate everything I owned the day I died 10 years earlier. It's not easy to do. And here's why. The state of Connecticut wants to make sure when you die that you don't have enough money to warrant an estate tax. And it doesn't matter that it's $14 million right now. They want to know. So they make you file something called a 706 NT, meaning no tax. Now, if they just said, hey, everybody, we need you to file this document when you die. But what they do is they put a lien on your house. And if you don't file it and you own real property, you can't do anything with that house until you file it. So if my stepsons tried to sell the house and only cleared their dad's estate or only cleared my estate and didn't clear their dad's, can't do it. You have to clear both estates. So it's important to know that because a lot of times folks will come in and say, I want to do a revocable living trust because I hear such nightmares about probate. I don't want my kids to have to go through probate. I hear you, but the important thing to remember is even if you do a trust, you're still going to have to file that document with probate. You're still going to have to file probate. You pay a probate fee for a $500,000 estate. The probate fee is $1,875. Goes up and down from there. If you're married, you only pay 50% of the assets you own jointly, so 50% of the house. And then when you die, so if my husband dies, I pay 50%, and then when I die, it's 100%. But it is the law. So trusts aren't always necessary. I hear your people about probate. I do probate all the time. It's long. Yes, it takes time. You have to wait to get appointed to be executor. And then there's the really eats up a lot of time. It's a 5-month waiting period. There's a 5-month notice period. They get put in the paper. It's literally in the paper. Come one, come all. Anybody who Jeanne owes money to, now's your chance to get it. And that takes up 5 months of time. But there's stuff that needs to be done, especially if you own a house. House has to be cleaned up. It has to be cleaned out. If you're going to put it up on the market, you can't sell it until you get the clearance. And the notice period is important because if there was no notice period, somebody could come up a year later and say, hey, wait a minute. Hey, wait a minute. What do you mean she died? She owes me $10,000. I want my money. You can't do that now because there's a notice period. You had your chance. It was in the paper. You should have gotten it. So probate can take about 10 months to a year. It does take time. But trusts don't don't tell the firm that I'm out of trouble. But trusts don't magically mean you get your money. If you have a relatively simple estate with a house and some bank accounts, trusts take time. You still have to sell the house. The money still has to go in the trust account. You still have to do an accounting. You don't magically just automatically everyone gets the money. They're very valuable. If they're listening to me right now, they are very valuable for certain reasons, but they aren't necessary for everybody. Yes, ma'am, you got a question? Do you have a question? Okay. No, okay. I don't think. So before we move on to irrevocable trusts, does anybody have any questions about revocable living trusts? Medicaid irrevocable trusts are different. This is an asset, revocable living trusts are not an asset protection trust. They don't get assets out of your name. They're not Medicaid protection. Medicaid irrevocable trusts do protect assets from long-term care. They can be designed to protect assets and also give you a stepped up basis for capital gains. They sound, they're amazing. They're the most perfect thing ever. Not necessarily. Normally what would happen is you put your house into the trust. It has to be there for 5 years. And if it's in there for 5 years and you need to apply for Medicaid, Medicaid can't see it. So again, I have folks come in and be like, I want to do a revocable trust. This is for me. I'm going to do it. And then I start talking about, okay, but you don't have any control over it anymore. It's not your house. You're giving it away. You're giving it to the trust. So you need to understand some of the rules that are involved with that. You can't get a mortgage. If you have a mortgage, you've got to pay it off. Oh, you can't get a home equity. You can't get a reverse mortgage. You can't pull any equity out of it. You have to make sure you have enough assets to live comfortably without that asset. You can't make any capital improvements to it. You want to put an addition on, you can't because it's not yours anymore. So if you put on an addition so that your kids can come live with you and then you need Medicaid, they're going to say, what's this $50,000 thing, money you spent? Oh, I put an addition on my house. That's not your house. That's a gift. That's a penalty inducing transfer. And you have to get through the 5-year look back. It has to be clear for 5 years. There are some aspects of control that you keep. So let's say I decide I want to put my house in an irrevocable trust. I pick a trustee. I pick David. So David, you're the trustee now. The house goes into the trust. I can live there for the rest of my life. We sign a lease. He can't kick me out. And then I decide, my husband and I decide, all right, you know what? We don't want to live here anymore. It's too cold. We're going south. We can't sell it. David can. So we go to David. We say, David, we want to sell it. Okay, whatever. So he can sell it. But the money, so if we sell our house for $400,000, he can buy us something for $300,000. He can really buy anything for $300, but that new house goes in the trust. That $100,000 goes in the trust and we can't have it. It's not ours. We can't touch it. We can't have it. It stays in that trust forever and ever. Let's say I go to David and I say, David, we're not happy here anymore. We're going to go south. And David says, no, I like that house. I'm looking forward to, inheriting that house with my brother. We're going to live there. There's 2 areas of control you do retain. Who is the trustee or trustees and who are the beneficiaries? So I can say, well, David, sorry, you're fired. And he's out as trustee. We go to Alex. Alex, if you want to sell that house, will you do it? Yeah, sure. So then Alex can be the trustee. So Alex can now be the trustee. He could sell the house. Money goes in there. But again, it's not ours to have. It's not our money to have. There is one aspect of it. The beneficiaries have access to that money. So again, you have to pick trustees and beneficiaries that you absolutely trust. If we run out of money, they can dip into it and pay bills on our behalf. So maybe you want to go to assisted living, they can take money out and pay bills for us. They can't give the money to us. They don't have to. Technically, the whole point of an irrevocable trust is that you're putting it aside for your beneficiaries, for your kids. So, the way I kind of look at it is it's your money, my money, I earned it, I saved for it. You know, you have to make, if you have a lot of liquid money and it's really, some folks it is, because sometimes it's a family home that's been in the house for generations and, or if they built it and they want their kids to have it. Okay, yeah, that's, you know, I get it. But it's not for everybody, because again, it's a lot. If you have a tax exemption on that house for being a veteran or an income, if you're not getting it anymore, because that house for all intents and purposes is not yours. So it's an important tool, and again, it's another estate planning tool that is important. It is useful for some folks, but again, it's just not for everybody. You have to sit down with somebody and really go through the ins and outs and make sure you know what you're doing, what you're signing up for when you do it. So does anybody have any questions about Medicaid? Yes, sir.
So,
Mhm.
so,
Mhm. Mhm.
They now have that house.
Right. Yeah. Yes, yes, thank you for pointing that out. Yes, you have beneficiaries on it. When you pass away, it goes to your beneficiaries outright, and it's free and it is after 5 years. If you need to apply for Medicaid, then they don't see it. But if you're married and one spouse does need Medicaid, there are some things you can do to shift assets around. You know, so it's, and I don't want to get into a Medicaid planning seminar either. There's lots of good resources out there on our website, and we do Medicaid planning seminars. But it's, you know, it's not as dire as Medicaid comes in and takes everything. There are things you can do. The key is if you get a diagnosis, especially a diagnosis where you have time, like Parkinson's or, you know, one of those kinds of, talk to somebody. And that spins me around to another, you know, be mindful of putting children on deeds to the house. If you've already done it, okay, that's fine, but you have to be mindful of what that means in the long run. So especially if you've owned your house for a very long time. So if you bought your house for $100,000 in 1975, and then you put your child on the deed, and this is not a financial planning seminar under any circumstances, I'm not giving you financial advice, but you've just gifted your child that $100,000 basis. So when they go to sell it, they're going to have, and they sell it for $600,000 after you die, they're going to have a huge capital gains hit. If they inherit it from you, they get something called a stepped up basis. So if it's worth $600,000 when you die, then, and they sell it for $605,000, it's a minimal capital gain. So that's number one. Number two, if you put your child on your house, you're opening up your one of your main assets to all of the life events of this child or your children. If they get divorced, if they get into a catastrophic car accident, if they file for bankruptcy, any life events that happen to them, that is now their asset, and it's open to being a part of their divorce judgment, being part of a lawsuit. We hope obviously none of that ever happens, but it can. It takes away your control for your house. I've seen it happen, unfortunately, where parents want to refinance or they want to sell, and the kids are like, no, I'm not doing that. I'm not letting you do that. I don't want, and sometimes for good reason, they don't want the mortgage or the loan is going to be on their credit, or they don't want to sell because it's a childhood home, and they can block you from anything you may choose to do for various reasons. So it's just talk to somebody first. If you're going to do it, just talk to somebody who knows what they're talking about in terms of elder law, just to make sure it's the right choice for you. Same with bank accounts. If you put your child in a bank account, it's their asset and it's open up to all of their life events. Power of attorney would give them the same authority to help you when you choose to have them help you, and it's not their asset. So again, it's all the ins and outs of just sitting down. It doesn't have to be me, it doesn't have to be our firm, but it's these little nuances that sometimes you don't think about, and we've seen happen, unfortunately, in a negative manner. Is anybody in the room? That's fine, that's different. That's different. Correct, correct. And that's what you're right. So if you put your child on the account, especially if you have 3 kids, but you put the child that lives in town on the account as a co-owner. And it sometimes works out, but if it's a significant amount of money, when you pass away, that's their money. And they don't have to share it. And it also, if something happens, if they get sued, if they bankruptcy, divorce, it's up for all of those life events because it's technically as much theirs as it is. Yes, sir. That's a good question. Yes, you can. You can, but again, you want to make, so the question is, folks at home, and I'm sorry, I'm not repeating these questions. Can you put cash into an irrevocable trust? You can, but you have to make sure that you have enough other money to live on. So yeah, if you have a significant amount of money, you want to put some away, you can, sure, but you know, you just want to make sure you have enough liquid assets elsewhere to live the rest of your life. Any other? So before I go to the chat, I don't know how many questions we have in there. It is important to use the right lawyer. Doesn't have to be me. It doesn't have to be my firm. General practice attorneys are great for a lot of reasons, but I have sometimes seen mistakes or just oversights. And it's not, again, it's not for any malicious intent. It's just sometimes they miss the nuances of estate planning. Estate planning, we only do elder law, we only do Medicaid, we only do probate, we only do that specific niche. And be mindful of online legal Zoom and things like that. You get what you pay for. So my own sister went to like freewills.com and I'm like, your sisters, but sisters. So just you know, they always know think they know more. Just be mindful to really try to use the right lawyer because you've got your documents now. What? So avoid safety deposit boxes. List of everyone you name are listed. The original will does have to be located when you pass away. Keep it safe or leave it with the attorney. You know, I've heard some horror stories about those. Avoid giving out copies of your will. You might change it. You might revoke it. You might do a new one, and you don't want copies floating around out there. It's nobody's business what you're doing. So same with the power of attorney. Keep it in a safe place until you're ready for it to use it. You might revoke it. You might change it. Healthcare is different. Healthcare, I do say, I'm going to make a completely different recommendation. Your people should have it because you just don't know what life is going to throw at you. You may, you know, you just don't know. So that should go to everybody you name. It should go to your doctors. It should go to your specialists. If you do change it down the line, okay. But life can turn on a dime, unfortunately, and the folks you name should have it ready in case they get that phone call at 2 o'clock. So I want to thank you all. Bailey, how are we looking at the questions in the chat? Oh, wow. All right. Well, good. Hopefully that means I answered all the questions. There are green cards in your folder. If you'd like to hand them up, please do. It only makes me better. And there is a mailing list. I promise you that the mailing list is not spammy. I'm on it for that reason. They send out some blogs and stuff maybe once or twice a week. If you'd like to sign up, please do. And the folks online, if you'd like to join in on the mailing list, I think all you have to do is just go online and sign up for it. So yeah, if there's no more questions, I want to thank you all. You've been a great audience. Shout out to Bailey for being my very able assistant tonight. I thank you. You're very welcome. So yeah, thank you all. And we did it in an hour.